Hello, I'm Chris Devon with the Professional Affairs Department of the Law Society of South Africa. Today we will be speaking to Eunice Masipa, who is the Vice President of the Law Society of South Africa, also a practicing attorney and a participant of the National Wills Week. Eunice, can you tell us why is it important to have a will?
Thank you so much, Chris. Now, I cannot overemphasize the importance of having a valid will. Firstly, you make it so much easy for your family to distribute your estate on your passing. And you also get to have a choice as to who will inherit your estate when you pass. So it is very important to have a will because you'll have a voice, after your death.
What happens if I die without a will?
Should you die without having a will, your estate will be distributed in accordance to the Interstate Succession Act. And in this instance, well, the act is generally fair, but in this instance, the estate will be distributed according to the degree of relations with your family. So if you had a spouse and children, they would first be considered. If you did not have, then your siblings and your parents, and in the absence of them, then your extended family may be considered. So, should you die without having a valid will, you would not have a choice as to who will inherit your estate.
What will happen to my assets when I die?
Okay, so it all depends. Do you have a will? Don't you have a will? So, if you have a will, your assets will be distributed to your beneficiaries that you have elected in your will. And if you did not have a will, then an executor would then have to be appointed depending on the value of your estate, and then it shall be distributed in accordance to the Interstate Succession Act.
How does the administration of a estate start?
So, when a person passes away, the first thing that would have to be done is the estate needs to be reported to the Master of the High Court. So, if the estate is below the threshold of 250,000 rands, you can approach the Master of the High Court directly, where you will be issued with a letter of authority. Now, if the estate is over the threshold of 250,000 rand, you would then need a legal practitioner or an attorney that would then report your estate, and a letter of executorship will be issued. Now, one thing to note is that whoever has the letter of authority or a letter of executorship is not the person who inherits the estate. That person is responsible to ensure that the estate is distributed accordingly and fairly to the beneficiaries of that estate.
Who can be appointed as an executor?
Basically, in your will, you can elect anybody or appoint anyone as an executor. It could be a family member or a friend. But in most instances, I do advise that if you are going to choose a family member, ensure that you maybe appoint an attorney as a co-executor. This is very important because then an attorney is able to ensure that the distribution of your estate complies with the relevant legislation. So, as the testator, you've got the freedom of choice as to who your executor can be.
Why should a legal practitioner be appointed in drafting a will?
Most importantly, because the legal practitioner knows the requirements that have to be complied with in order for a will to be valid. And secondly, a legal practitioner will be able to identify issues that may arise with your will and give advice and solutions for that.
Thanks, Eunice. It has been very informative.